students for teachers only?
Yes, 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 sure. So, respected Professor Dr. A.P. Singh ji, Dean USLLS GGS Indraprastha University Delhi, respected Professor Dr. Usha Tandon ji, Dean and Head Faculty of Law, Department of Law, University of Delhi, my dear colleagues and students, a very good evening to all of you. We are assembled here virtually to hear a lecture about one of the most intriguing and intricate concept of human intellectual quest, that is called justice. From times immemorial, the scholars have attempted to deliberate upon the concept of justice, but this concept itself remains elusive in different geopolitical and socio-economic contexts and different historical phases. Sometimes it is also said that the concept of justice is so much subjective or so much intertwined with politics and other concepts that it would be very hard to objectively formulate it. This has also been further argued by the critique that law and justice are two different domains and one should not try to mix both. But despite all this criticism, scholars have attempted to conceptualize justice from times immemorial. From Aristotle to Rawls to Logic, we have so many books and so many writings about the concept of justice. But this topic has never been saturated. It is still awaited new concepts, new logic, new topics. In all these things, the concept of justice, nyaya or dharma, that was already there in most of the ancient civilization, that also need to be reworked, that how those concepts are going to help our own legal domain. Today, this evening, we are all going to hear a very thoughtful lecture from Professor Dr. A.P. Singh, and we find answer to most of these questions. With these words, now I invite our respected Dean, Professor Dr. Usha Tandon ma'am, to give welcome address. Ma'am.
Thank you, Santosh. I hope I'm audible.
Yes, ma'am.
Yeah. Respected Professor A.P. Singh, Dean, University School of Law and Legal Studies, GGSIP University. Dr. Seema Singh, Dr. Santosh, Dr. Ajay Sonawala, I hope he's here, even though I couldn't see it on the screen, and my other colleagues, students and whosoever is connected with this particular program. It's my pleasure to welcome you all to this webinar on a very, very serious subject, theories of justice. When this topic was presented before me, I was just wondering, where is the subtitle? I was looking for that. Why? Because in the absence of the subtitle, you really cannot make your mind that what is the thing on which the speaker really wants to speak on. And perhaps it is the absence of the subtitle that I am here. So that I really want to know those points. I knew Professor Singh that his areas of interest are environmental and constitutional law, but I never knew that, you work in legal philosophy also, this particular paper. And when Santosh has given me a copy of your profile, I came to know that you had certain international exposure also in none else than the legal philosophy itself. So therefore, I think you are a most appropriate person to speak on this particular topic with this kind of experience with you. Now, yes, this is true that this particular topic has attracted the attention of scholars. Various theories of justice have been established. Generally, we talk about more of Greek and those Roman philosophers, whether it is Plato or then later on the others. If we come to 18th century, then we talk about John Stuart Mills. And of course, no discussion is complete without mentioning John Rawls' theory on this theory of justice. But I think much before these scholars, as far as Indian jurisprudence is concerned. So the concept of justice dates back to in Indian jurisprudence much far or before, when we talk about Greek or these Roman philosophers. And in simple words, that we have been saying the concept of dharma. So justice was related with the dharma, but then dharma also did not have one specific meaning. Some related it, um, of course, with righteousness, morality, ethical principles, but then others related it with more duty. What is the duty of a person, so on and so forth. But one of the things is there that when we take all those scholars who have contributed towards the theories of justice, including those scholars which are taught in the law schools and the law classes, we find that if not all, most of those scholars have been philosophers. Their basic discipline was philosophy, who were political philosophers. So I really wonder, and I would like to know from Professor AP Singh, is there any legal scholar who has contributed something on the theory of justice? Even though we rely heavily on those, even though we take John Rawls was not a law professor. We all know that. He was a professor in the philosophy. Or whether it will really make any difference if a professor from philosophy is defining the concept of justice, and if a professor of law is defining the same concept. So, with all these queries in mind, we look forward to hear the speaker of the day. And It's over to you, Professor APC. I mean, to enlighten us on what aspect you would like to bank upon on this.
Thank you, ma'am. Thank you so much. In fact, Dr. Santosh and uh, respected Professor Tandon has made my task easier, because once questions around these subjects get articulated, the subject area gets demarcated. In fact, good or bad, I didn't have much of a talk with Dr. Seema Singh for a variety of reasons. I was more or less running around these days. So I was also wondering what exactly, but then I thought about it, and I'm being slightly over ambitious. I'll come back to that, but let me first put on record my sincere gratitude and thanks to respected Professor Usha Tandon for permitting me to share some of my views with the scholars here. Dr. Seema Singh, very distinguished scholar, and other distinguished faculty colleagues from Delhi University, law faculty, and student friends. As I said, that it appears to me that I'm slightly over ambitious. What all I'm going to do, let me just explain a bit of it. Uh, I Because justice, as Dr. Santosh was talking about, is something which is difficult to be explained objectively. There is a lot of subjectivism, political thinking, uh, contemporary ideas that affect the idea of justice in a big way. So what I do is I try to explain the idea of justice from a common man's standpoint first. That is my first task. Then, though I keep on quoting scholars from, across streams and centuries and millenniums, but I concentrate on contemporary philosophies. And as Professor Tandon was talking about, John Rawls, basically, his critique by Michael Sandel, and also the idea of justice that Amartya Sen talks about. I confine myself to these 2, 3 scholars, and we, being students of law, can appreciate it. That even covering this area in, say, 2 hours is not an easy task. And over and above, I'm trying to just explain as to how this philosophy has got reflected in our legal system, constitutional system. Now that also has a lot of dimensions. So I will be confining myself to few dimensions of our own legal system, where we had tried to sort of manifest, you see, the idea of justice in our own system. Now, for the purpose of putting things in a structured way, I have prepared a PPT which I shall share with you. Just bear with me. I hope my screen is getting shared now.
Yes, sir.
So this is my PPT. Is it visible?
Yes, sir, it is visible.
Okay, so I was somewhere here. Okay, I was just looking into it. I'm just trying to appreciate the idea of justice from a common man standpoint, and then several philosophers, and then coming back to the Indian system. Now, as we have been talking about it, that justice, like many other universal concepts, is actually a subject that is almost incapable of being defined precisely. It has different contents, different meanings according to the kind of a political situation around that we have. But in all situations, it refers to a situation where everything appears to be in right place, where you feel that every relation is in correct balance in the social system. And then in every arena of social and political life, everybody is getting his due. Could it be economic realm or society or legal realm, whatever. But ultimately, everybody is enjoying his dues. That is the basic idea that a common man understands from the idea of justice. That is one point I would like to make. Now, looking at it, you see, etymologically, the expression justice has been derived from a Latin word, zunzere as we call it, which means binding or tying together. So say, for example, when you do justice to me, you become my real friend. It binds us for all times to come. So justice is that kind of a binding element which connects individual to individual, individual to society, society to a larger community to the international, I mean, everything. So when, you know, like for example, Sri Lanka, our neighbor, undergoing a tremendous, you see, economic pain these days, when India helped in, you see, in variety of ways by contributing in terms of money or fuel or whatever. A lot of people said that, well, India has been contributing and China has not come to our rescue. So the idea of justice actually binds people together, binds societies together, binds these collectivities in which humans are generally, you see, known to live. So it is more or less like, just by way of a reference, you know, even the expression religion is, you see, have a similar content or a similar, you see, implication for that purpose. Re means once again, and lesio means to bind. So religion also means to bind together, though religion is a very different kind of a thing, the way we understand it today. But otherwise, it has the same content, more or less. And then a very strange, you see, thing that we come across in St. Augustine's work, where he says that, you see, what distinguishes a state from a band of robbers is actually the element of justice. It's very interesting statement that St. Augustine makes. So just as band of robbers, by putting you under a threat, extorts things, state probably also puts you under threat and it extracts things from you. So say, for example, the non-payment of taxes would be punishable by imprisonment or whatever. So you have to pay taxes and all that. Other things are there that I'm not, you see, talking about. But unless the state machinery is informed by the element of justice, the idea of state is never complete. So what distinguishes state from other human organizations? You see, everywhere in every other human organization as well, there has to be some kind of a element of justice. There is no confusion about it. But nevertheless, the state is such an entity where the idea of justice is something which goes almost along with it. Without justice, you cannot simply think of a state system. That's how we look at that. And therefore, more or less in the same manner, if a state comes up with an unjust law, people would say it is no law at all. And one can go back, you see, to the Gopalan's judgment and Justice Fazal Ali's dissent, that if law is not simply law because it is, you see, passed by the legislature, it has to have those essential characteristics of law which make it law. So these are some of the things that we need to appreciate and understand. Now, just looking at some of the common man's standpoint as to how do we look at the justice element. It has to be speedy, but very considerate. So it should not be delayed so that somebody might consider that the justice is delayed. You see, justice delayed, justice denied almost. But at the same time, justice should also not be hurried so that it becomes buried. That is one of the ideas. It has to be affordable as well. Then some of the scholars like Aristotle would talk about basics of justice in terms of distributive and corrective justice, which means that the basic function of the state system, to which Amartya Sen keeps on going back over and over again in his works, right since 1960s, for which he has got Nobel Prize as well, that basically the idea of the state is to distribute goods and bads. Goods and bads not in the sense of material goods, but goods in the sense of all kinds of, you see, tangible and intangible entitlements. So the first idea of a state is to ensure fair distribution of goods or those entitlements. And in any case, that balance somehow, if it gets disturbed, then the function of the state is to come into play and correct that imbalance. So corrective justice, this is how he talks about it. And Amartya Sen keeps on going back to that. It's a very basic idea which can be understood from common man's standpoint. Then slightly deeper into it, there is a concept of protective and compensatory justice. So we have a lot of things in our constitution. So in case certain communities in a system have been denied, you see, a proper place in the social system, and therefore they have suffered and have, you see, have become laggards in the community, have become backward in the community, have become, you see, what the expression that we generally use, Dalit in the community. So for that purpose, to compensate for those historical injustices is what is the idea of compensatory justice. We also talk it protective justice in the sense that, you see, otherwise, if we look at it from constitutional standpoint, the idea of discrimination is a constitutionally prohibited category. But then, for the purpose of protecting certain people, you can discriminate. So we call it protective discrimination, which is an idea of justice itself. Okay. Then justice has to be uniform, obviously, and certain. I mean, the moment you see, lose that faith, element of faith, that justice shall certainly be done. In fact, the whole system, you lose faith in the whole system. And the first casualty is justice element. So therefore, justice element is not only, you see, which actually binds people together, binds collectivities together, communities together, but it is also more or less like, you know, like dharmamiti dharayat, as it talked about in Mahabharata, that dharma is something which sustains the community. So basically the element of justice is something which sustains the community, more or less in the similar fashion. There are a lot of other things, but I'm approaching the subject to begin with from a very common man's standpoint. And therefore, it is generally said that justice should not only be done, but should appear to have been done. That is, that demonstration of justice having been done is a compulsory element of justice process. Amartya Sen later on would talk about that justice is not something which can be talked in terms of those binary expressions, achieved or not achieved. It's a continuing project. It's a continuum, as he puts it. So therefore, the justice is something wherein all the time you need not only do justice, but should appear to be doing justice, which means that there has to be some kind of a demonstration that justice is being done. And then justice is also a reservoir of rights and duties. Something that you think is just, you create a right. Something you see that it is unjust, you create a duty on somebody's part. So somebody, you see, a holder of a right, somebody a holder of a duty, and that's how the idea of justice is achieved. So ultimately, the justice actually functions as that springboard of variety of values in a constitutional system, in a organized system. Right since the days humans have started living a politically organized life, the idea of justice has been the reservoir of variety of values. So say, for example, if you look at, say, Indian Constitution and the preamble of it, you see every element of it, though justice is a defined category under the Constitution. So justice, social, economic, and political, as we generally talk about. But nevertheless, every other value that we have under the Constitution can be associated with justice. So justice actually forms the very arc of the constitutional system, or any kind of a system. Any kind of an organized system, if it lacks justice, the system will not hold together. That is a very simple idea. And that's how though it's slightly an innocuous comparison, but you see, it appears to be very simple from a common man's standpoint, that justice is something that holds the society together, is something that informs, you see, variety of values into the system. It induces values in the system. That's how we look into it. And therefore, you see, when Dr. Santosh was also talking about it, the courts the courts that we have that deliver judgments, or we say deliver justice, they are not known to be courts of justice. They are known to be courts of law. Someone who must have framed these expressions must have thought about it, I believe. I'm not getting into the details of all that or evolutionary aspect of it, but it's just a simple idea that somebody who must have coined these expressions must have thought about the limitations of a litigative system, wherein, you see, you have that, two parties fighting, trying to draw the attention of the judge, an independent umpire who will deliver an opinion. So in this kind of a litigative environment, justice is not possible to be delivered in an objective fashion. Therefore, somebody must have designed this expression, must have coined this expression, and, you see, called these courts the courts of law, not courts of justice. Though the endeavor of these courts is always to deliver justice. We always, you see, as and when a lawyer would stand up and present his argument before the court, he will, you see, invoke the jurisdiction of the court and you see, appeal to the judge that he delivers justice. In the name of justice, that, you see, courts can do anything or everything. You see, Article 142 is not something which has just, you see, an exception in the constitutional system. But justice, in fact, cannot be delivered in, you see, rules confined system. It is something where a particular body need to have that, you see, a lot of elbow room, a lot of space to really deliver justice. And therefore, I see the Supreme Court has been given that kind of a mandate under our constitution, that for the purpose of doing complete justice, it can actually pass any kind of an order, judgment, or whatever. So this is how we need to understand. I have just tried to explain or just touch some of the ideas around the justice element from common man's standpoint. Now let me come back to the Dr. Seema or Dr. Santosh. Is it that the PPTs are visible? Hello.
Yes, sir. It is visible. It is visible. Raws, yeah, visible. Yeah.
So let me just get back to the most important, as Professor Tandon was talking about, that in contemporary thinking, you cannot talk about the idea of justice at all without talking about Rawls. That's how we generally understand it. And Rawls was not a legal philosopher. Well, let me just, before going to other questions, let me just try to explain bit of a, framework of the idea of justice or theory of justice, as Rawls calls it. And he calls it a theory of justice, right? Not the theory of justice. We need to understand it. So he is making an attempt that he explains in his Justice as Fairness after Michael Sandel has criticized him left and right. So he has come up with another publication to justify his attempt at the idea of justice. So his idea of achieving an ideal theory of justice is actually known as Contractarian theory of justice, which is very different from what Hobbes, Locke, Rousseau, etc. talk about, because they talk about a social contract theory or social compact theory, as generally some political thinkers would talk about. This is slightly different. In fact, I'll explain it. It is state of nature is not something on which Rawls is actually putting in a lot of emphasis. For him, the idea of justice is slightly different. So there is a contractarian theory of justice that he talks about. Now, what exactly does it, what are the basic propositions of his theory? So generally, he believes that people in general are self-interested people. No confusion about it. From Hobbes' perspective, the people being self-interested will, the state of nature is not brutish, nasty, and short. Everybody is running at each other's throat, a lot of competition, and so on and so forth. But from the point of view of Rawls, people are self-interested, but this does not make them blind to the rational assessment of the best strategy that they can have for the purpose of maximizing their self-interest. So the people, generally speaking, it cannot be said that he is talking about the state of nature, because he is not referring to a historical event. Rather, he's putting things in a very abstract format. So people are generally self-interested, and they are capable of making a rational assessment in every situation as to what is the best strategy for them for maximizing their self-interest. And therefore, they act morally. Two things they do in their, rational self-interest. They do two things. One, that they act morally. And secondly, they consent to governmental authority. These are the two things that they do. This is very different from, contract theories and all that, but I'll explain that. I believe that those contours of differences will emerge when I explain it further. So he believes that common man, we people, are motivated to accept morality because we know it, that if we do not follow morality, then we are vulnerable people and can be subjected to depredations by others. And we, in our rational self-interest, self-assessment, we make this conjecture that cooperation is the best strategy. And therefore, number one, we act morally, and we know that by cooperation, all of us shall get benefited. This is the basic proposition that he makes. So therefore, Rawls make a conjecture of what he calls the original position. Now, original position is not like a state of nature. In fact, about the state of nature, there is no agreement, and Rawls does not make an effort to come to that agreement at all. Rather, he believes that there are a few propositions that humans think in the initial state. So he talks about an original position where there is a wheel of ignorance. Nobody knows what kind of a role he is going to play on the stage when he is given, you see, the part to play in the world. So therefore, say suppose for example, we are supposed to enact a play on the stage. Somebody might be playing a soldier, somebody might be playing a king, somebody might be playing a lame person. So what shall be the rules that shall justify every person's needs and how he shall contribute in that play? So therefore, before the play starts, there has to be a wheel of ignorance as to what kind of a role one shall get. Behind that wheel of ignorance, in that original position, where these basic, minimal, you see, understanding of human nature is there. So what he says is that there are minimal other directed desires and capacity for rational interaction with others. These are the two things that he believes are there in the original position of nature. There is no argument as to what kind of a state of nature is. He just believes that people have certain expectations from others and that they believe that they are capable of interacting with people rationally and in a moral way. That's how he presents the initial position. Now, the argument that he's trying to make is that without rules of justice, number one, cooperation shall not be there. And number two, the situation of the community would be worse off. So he is trying to make an argument that people behaving morally and, you see, cooperating each other will benefit all of us. In the absence of rules of justice, everybody would be worse off. Cooperation, if there's no cooperation, we shall be subjected to or vulnerable to a lot of depredations and what we call in Hindi, you see, jiski lathi uski bhais type of a situation might emerge. So therefore, rules of justice are the first and the most essential ingredient of any kind of a organized system, socially, politically, all kinds of things. Without the idea of justice, organizationally living together by humans is not possible. So justice is, even according to this, justice is what brings people together. So cooperation and, you see, the moral behavior, this is how, you see, leads us to those justice elements. So the initial situation, as I was talking about, is marked by wheel of ignorance. Nobody knows what kind of a role I'm going to play on the scene when a role is given to me, a king or a queen or a, you see, a lame person or a poor or whatever. Now, this kind of a situation is subject to two conditions. Number one, that there is what he calls a differential rule. To understand it from a commoner's perspective, it simply refers to what we generally teach under Article 14. Different kind of rules for different kind of people. So equality is not something which is a blunt equality. Equality amongst all, irrespective of his or her station in life. In fact, the idea of equality, you see, the idea is basically, it embeds within it that if what we call as, you see, Aristotle puts it in, what is that, Nicomachean Ethics, that equal treatment of unequals. You see, there is not, and the statement goes like this. I was slightly confused about it. There is nothing as unequal. There is nothing as unequal as the equal treatment of unequals, which means that if we treat unequals equally, then also inequality shall be generated. So there has to be some kind of a different treatment for different type of people. So therefore, differential rule, there has to be differential rule, number one. Number two, public position of power, all kinds of power positions in the system shall be open for all. These are the two conditions for the wheel of ignorance status. Then there are two fundamental rules of justice that he talks about. That each person has to have equal right to most expensive liberties. Expansive is like most expanded. Liberty in its most expanded format. Every person has an equal right to most expansive liberties in its most expanded form, not in a very, restricted format. Number one, every person is entitled to most expanded format of liberties, number one. And number two, and this is the most important thing, wherein differential rule comes into play as well, economic inequalities are to be arranged in such a manner that they benefit the least advantaged sections of the society. You will have to adjust inequalities. There are a lot of formulas that are given, and you have a lot of critiques for that purpose. Equal distribution, for example, is something that has been criticized by Dworkin in a certain context, where he talks about that suppose you have 100 people and distribute 100 rupees to each of them. Next day, everybody would be unequal once again, because somebody might have spent the entire 100 rupees, somebody might have added into it, somebody might have invested in it. So everybody would be unequal the next day. So distribution alone doesn't help. In fact, the system has to be treated with that idea of differential rule. So economic inequalities, if they exist in a society, and the whole system has got to be arranged in such a way that it benefits the least advantaged section of the society. So say, for example, we have Article 37, 38, which talks about the distribution of means of economic control are to be distributed amongst people in such a way that they subserve the common good. To me, it appears to be, a restatement. So though Rawls's theory comes later after Indian Constitution, but it appears to be similar statement. That is what I'm trying to explain. Now, some principles. I'm just picking up a few here and there so that you see the idea of Rawls is complete. What he believes, and he states in very explicit terms in his theory of justice, that equality cannot be achieved by worsening the position of disadvantaged section of the society. Please understand it. He is not talking about equality in the absolute sense of the term, but equality which is suffused with a lot of values, with all kinds of differential rules associated with it. So any kind of an ideal of equality is not achievable if the position of disadvantaged people is not taken care of. Okay, that is one. Morally arbitrary factors should not decide our life chances. What is morally arbitrary? Somebody is born blind. Somebody is born, without, he's challenged in hearing, or is lame person, or in variety of ways. So these are morally arbitrary factors. Should they decide our life chances? No, it's not. Therefore, the very idea of equality under Indian Constitution has been defined in terms of equality of status and opportunity. So if a person is, born morally arbitrarily find himself in a very difficult situation, then that difficult situation should not decide his fate. He should be helped by the system. In this context, a very small idea that comes to my mind from Indian philosophy, I'll just talk about it in a couple of minutes. So there is something in Indian context we say Matsya Nyaya. What is Matsya Nyaya basically? It is more or less like in Hobbesian statement of nature, that in the state of nature, everybody is self-interested individual and is running at each other's throat, and therefore the life becomes brutish, nasty, and short kind of a thing. So briefly understood, the Matsya Nyaya idea, the implication is that the bigger fish eats the smaller fish. That is the state of nature. But then we believe, and this is how we need to understand and appreciate the idea of justice, that when we graduate from that primitive society where the state of nature prevails, or Matsya Nyaya prevails, when we graduate from that state to a civilized state of governance, then the bigger fish would not eat the smaller fish. You would become entitled to be called civilized people only when the bigger fish, you have been able to achieve a system, to usher into a system where bigger fish does not eat up the smaller fish, but rather the bigger fish protects the smaller fish. That is the idea. This is exactly what you see Rawls is trying to say, that morally arbitrary factors should not decide our life chances. Simply because I'm born small does not mean that I cannot become big in the life process. The system should provide to me all kinds of opportunities so that I can prosper in my life process. And then all positions on the basis of merit, I have already stated that. And all opportunities, and everybody, you see, has opportunity to acquire those skills which shall determine the merit. This is the only way to ensure that, you see, everybody is entitled to every public power position. This is how, you see, Rawls is trying to say. He perfectly believes that large inequalities are always bound to undermine civil liberties. If larger inequalities are there, the civil liberties are bound to be undermined, are bound to be, you see, there shall be a chaos if large inequalities are there. So therefore, the system will have to think, and it is in that context that, you know, Article 37, 38 of Indian Constitution becomes relevant and important, that a state shall ensure that the means of economic control, they subserve the common good, that they are not controlled by few people. Now, we need to understand that and I have explained it in the beginning as well, that Rawls' initial position is a hypothetical abstraction. It's not a historical event. He is not at all trying to ensure or trying to explain what the state of nature is, what the initial proposition is. He just, you see, in that initial position behind the veil of ignorance, he is just, you see, hypothesizing something, that these are the basic conditions in which the rules of justice shall be decided amongst the collectivity of people. So what the attempt that he's making is, he's trying to demonstrate that signing a contract is not important. Signing a contract to establish a society is not what is important. What is important is that all of us must be willing to accept as rational persons to be constrained by the idea of justice. Means by the idea of justice, by the rules of justice. All of us should be constrained by that. So therefore, to Rawls, the principles of justice are more fundamental than social contract. Any kind of a historical event in terms of social contract or social compact is not relevant for him. And therefore, he is not arguing at all. He simply believes what is more important is to, you see, ensure that people readily accept, are willing to accept that their, you see, rational will is actually constrained by the rules of justice. That's how he talks about. Now, the major critique of Rawls that we have in terms of Michael Sandel's critique, whereby Michael Sandel seeks to explain that the initial proposition of wheel of ignorance is something that turns individuals into unencumbered selves. What does that mean basically? It means that any kind of an individual, irrespective of his position in life, irrespective of his own, you see, unique potential, irrespective of, you see, the situation he is stationed in, irrespective of the kind of education, his station in life, he can be assumed to be an abstract agent in which he can accept any kind of a rule, any kind of a role. So rules of justice are something which have to be determined by the person who assumes himself to be an abstract agent of his own choice? Is it that the people are born? The people are born with certain special qualities. The people are born with certain special potential. They are, you see, in a particular situation, in a certain geographical context, they develop their own qualities. You know, some people would develop certain potential in a certain way because they are born in a certain area. It just reminds me that a small village in our neighborhood, I mean, in our NCR region, Meerut. I don't remember that place right now. It's a very famous place where almost each one in the village has that potential, you see, to develop into, you see, his acumen in archery. There is a village in Meerut. It has given a lot of national players. You see, that is small village. So what is so special about that village? Now these are just some examples. In fact, if you remember that French philosopher Montesquieu, who talked about that, you see, human institutions are designed by you see, geographical conditions, geological conditions. He believes that. So the thinking of the people is actually shaped by the kind of a system they are born in. So if you believe that people behind the wheel of ignorance can really turn themselves into unencumbered selves, it is almost, Michael Sandel says, it's an impossible idea. In fact, it is even hypothetically, you cannot think in terms of having such a wheel where people just can forget what basic characters they have, what community they are born in, what kind of a geographical conditions they are born in, what kind of difficulties in the life process they can feel, and all that. Family ties, their unique potentials, you know. I just give you an example. You see how Gandhi would explain, just for the purpose of underlining the idea that I'm trying to talk about. Explaining the idea of education, Gandhi says, by education, I mean drawing out of the best in the child and the man. And in fact, most of the philosophies, John Dewey also explains the idea of education more or less in a similar manner. I'm not going to quote him in any way, but more or less a similar fashion. Most of theories on education believe that every individual is born with certain potential. And therefore, the idea is to develop that potential. Like if somebody is born with, you see, say for example, in potential in athletics, you cannot make him, you see, a wonderful administrator. A person who is born with certain bent of mind towards learning process, you cannot make him, you see, a person who can labor in the open field, something like that. You know, you cannot go against the tide of, you see, our basic potential. So what all we can do is, Gandhi would put it, that the by education, I mean drawing out of the best in the child and the man. Whatever best we have, you know, that is something we need to, you see, evolve and develop so that we can contribute the best in the society. It's not only humans. This is true about collectivities as well, human collectivities. So some collectivities would be, you see, more interested or more expert in producing some special things. It's not because they are simply, you see, expert, or they have, you see, developed that idea by practice and all that. Sometimes they are born with certain potential whereby they can do some special things. So the moment you think in terms of wheel of ignorance, Sandel is trying to explain that you are talking in terms of assuming an unencumbered self, which is absolutely an impossible idea. Even hypothetically, thinking about such a wheel is not a possibility. So this is one very important point. As I was talking about, it turns a human individual with very special qualities as an abstract agent of choice, as if he can pick up anything. So if I'm given the choice, I can become an administrator tomorrow. Tomorrow I can become an athlete. Tomorrow I can become an archer. Tomorrow I can become somebody else. Is that possible? That is not possible. So abstract, you see, unencumbered self, an abstract agent of choice, is something which is not possible in the wheel of ignorance. It actually separate an individual from his personal attributes, his own ends, his community, the history. It's all an impossibility. You cannot, you see, separate, detach an individual from the kind of a system he's born in, the kind of history that he has, the kind of attributes that he has, you see, the kind of beliefs, processes that he will have. All things are very unique to that individual. So the kind of an individualism that he is trying to expound actually disallows any kind of a role of the community in shaping the personality of an individual. This is the third very important point. You know, it is for this reason that Michael Sandel, though he doesn't like it, and in fact he has criticized it, but he has been presented as a communitarian philosopher vis-a-vis an individualist philosopher called John Rawls. That is the kind of an expression a lot of Joseph Ras, for example, talks about it. So he doesn't like it, but then you see he explains it, that the kind of an individualism that Rawls is talking about is something wherein the role of community in constituting the personality of an individual is absolutely ruled out. You see, the possibility of a person's meaningful identity, what kind of a person I am, what I would like to be in my life process, what my community, what kind of expectations my community has from me, what kind of a, you see, expectations my collectivity had, you see, in because everybody contributes in the growth of an individual in the community. So there are a lot of people, not only family, but other members of the community also, you see, contribute. So that system also had expectations from that individual. Is it a matter of cognition or a matter of choice? Understanding myself and trying to just, you see, achieve a certain goal that I associate with my unique personality in view of the very unique circumstances of my community. Is it a matter of choice or a matter of cognition? It's not a matter of choice. I'm born with certain potential. I'm brought up in a certain environment, my socialization in a certain environment. All this is a matter of cognition. I need to understand, realize, and appreciate the kind of a potential that I have. And therefore, a lot of scholars today the psychologists particularly, nowadays there is a lot of technology available now, whereby they will subject a child at a certain age to certain questions and all that, and certain processes, and then they will tell you, okay, if you send him into, say, engineering side, he would be a successful individual. What does it mean? A lot of psychologists would say, follow your dreams. What are these dreams? What does it mean, basically? So if you believe in, you see, the kind of initial position or the wheel of ignorance that Rawls talks about, this creativity of an individual born with certain potential. You know, in Indian philosophy, there is a possibility in every individual from what we call Nar se Narayana tak ki yatra. From a commoner, you can become almost a god. That is the possibility that a person has. Is it possible in the state of wheel of ignorance? Is it a matter of choice for us? That is the kind of a critique that Michael Sandel puts, you see, vis-a-vis the philosophy of John Rawls. Friends, moving on to, because I'll just touching these issues and shall then move on to the Indian position as well. I quickly summarize the idea of justice of Amartya Sen as well. Obviously, points I'll be touching, whereby I'm trying to just put a, you see, image before you, that this is the way Amartya Sen is talking about. The entirety of the philosophy is obviously not possible to be covered in a very short session. Now, Amartya Sen's idea of justice is very different from the way Rawls is talking of, or even Dworkin for that purpose, or even Michael Sandel or Joseph Raj, they are talking about. Amartya Sen believes that the project of justice cannot be viewed in binary terms, achieved or not achieved. It has to be understood as a continuum, as a process, whereby almost everybody is trying to ensure justice. That is the way we understand. How do we try to ensure justice? Through systemic means, through an individual, through certain values, you see, that we cultivate amongst, you see, individuals and youngsters. How do we achieve justice? So justice is a more or less a continuum, and you see, something like which is a process. So there are two things. um, it is not merely, and like I'll quote somewhere I have included Immanuel Kant, who talks about that if the institutional mechanism is properly worked out, it can take care of devils as well. I'm not getting into that. I'll quote it somewhere later. But you see, what Amartya Sen is trying to appreciate and explain is that for the purpose of achieving the idea of justice, which is not in terms of achievement and not non-achievements, but in the sense of, you see, realizing it slowly, gradually, in a continuing manner, we need to think of two things. It's not simply institutional mechanism that if you design your institutions properly, then your idea of justice would be achieved. But you will have to also see the quality and the ideas, or the quality of those people who operate these institutions. So it's not merely the institutional mechanism that is important, but even the people who operate these institutions, and therefore ensuring, as Kant would put it, a very, you see, healthy and very sound institutional mechanism would not ensure justice. Rather, you will have to ensure a continued supply of good manpower, incorruptible manpower, that would be able to ensure justice. So courts would be making efforts to ensure justice. So there have to be good people around. So simply because, you see, there are certain rules and regulations that shall bind the judges. They may deliver judgments, but the justice may not be delivered. For the purpose of delivering justice, you need to ensure, as Justice Krishna Iyer would say about it, that, you see, opting for honest people would go a long way in ensuring judicial creativity. So therefore, we need to understand and appreciate it, that institutional mechanism alone does not help us in realizing the goals of justice, in realizing the idea of justice, in realizing the object of justice. This, you see, one can just recall, you see, what transpired on 25th of November 1949, a day before, when we adopted, enacted, and given to ourselves this constitution. On 25th of November, it's a long session of the Constitutional Assembly. So this long session, there were a lot of people, a lot of speeches were made. Pandit Nehru spoke, and Dr. Ambedkar also talked about. And you see, these two figures, and the speeches are available now on Parliament of India website as well. You see, they talked about a different language, but about the same thing. So Pandit Nehru said, we have a wonderful constitution, a paper constitution. The challenge lies in turning this paper constitution into a live constitution. And Dr. Ambedkar also talked about it, that we have a wonderful constitution in our hands, but does it help us? So he says, from tomorrow we are entering into an age of contradictions. He started his speech like this, and then explained that you have a wonderful constitution, but without ensuring its proper implementation, without ensuring, the people with the, you see, in whose character the values are embedded, the constitution will mean nothing for us. That was the kind of an idea. This is exactly what Amartya Sen is trying to say, that there are two things for the purpose of, you see, achieving the idea of justice in a processual manner, in a continuing manner. One, institutional mechanism obviously has got to be, sound. And he, in fact, brings in an element of empiricism into it. I'll come back to that. But this, the institutional mechanism alone will not help us in achieving the object of justice. Rather, we will have to ensure that a proper supply of manpower to man these institutions also there. And this is what he talks about in terms of transcendental, institutional transcendentalism, the transcendental idea of justice. So, health of institutions is as important as the idea of justice. And health of the institutions is ensured by healthy, morally healthy individuals manning those institutions. Therefore, there has to be a comparative judgment of what is just and fair. The idea of justice is not something that you can define once for all. It has to be judged, over and over again. It has to be relooked over and over again. So there has to be comparative judgments all the time as to what is just and fair in a given social context. There have to be comparative merits of different social and institutional settings. So there may be a certain institutional setting in a given, system. Say, for example, in the UK, is it that a, peculiar institutional setting is delivering better in UK? Can it help us? Or a particular institutional setting was there 30 years back, 50 years back in our own country, whether the current institutional setting help us or we can change it. So what do we do? So comparative merit of different social and institutional settings, it has to be done. There have to be reasoned differences as to what is a just society. And this just society has got to have the idea that, the justice is not one simple, cut short idea. There has to be choice of alternatives to ensure justice. And this is where Professor Amartya Sen brings in the idea of empiricism into the idea of justice, an element of empiricism into the idea of justice. So we as scholars need to keep on doing those comparative studies, comparative merits of different social and institutional settings, and have to, see that there shall be reasoned differences amongst the members of the society as to what is just society. Just society to me would be something different. Just society to you would be different. So there has to be a choice of alternatives, and it has to be rational people. The system which has rational people within it acting morally will have to have all these reasoned differences as to what is just society and variety of choice of alternatives. Friends, he talks about, and this is an idea that Amartya Sen has been working right since those days when he was working in Delhi. What is that? Delhi Institute of Economics or something like that during 1960s. It actually, the kind of a work that he did on African famines was during the phase when he was working in Delhi. And this idea he keeps on referring over and over again in his work. So he assigns a definite role to the state as a dispenser of goods and services. I categorized it as goods and bads, distributor of goods and bads. So say, for example, jobs. So state is somebody who controls the jobs. The jobs have got to be distributed properly to the most deserved, to the one who, will do the best to the community. So he actually, he assigns a very definite role to the state as dispenser of goods and services. In fact, it is in this context that he talks about, as I was talking about his studies, which he did during his days in Delhi, wherein he worked on African famines. So he came up with this idea that famines are not created by lack of food, but by breakdown of state's distributive machinery. Famines are caused by the breakdown of, the distributive machinery of the state. That is what he talks about. And there are several examples. One example that I came across very recently in one of the talks that Sasi Tharoor gave was that, you see, during 1940s, the Great Bengal famine that we talk about was something which was not a natural calamity. It was actually a man-made calamity. So when, you know, the shiploads of grains which were meant to be exported to India were diverted to European, you see, for the purpose of securing their food safety, for the purpose of, you see, stocking them in their stocks. And you see, a lot of hue and cry was there in India. And the people who were responsible for Indian administration at that point of time, even Britishers, they actually talked about it and wrote a lot of letters to the British administration at that point of time. And it is said that, you see, Churchill, when he was briefed that if these shiploads of grains are not, you see, sent to India, then people might see die out of hunger and all that. So he apparently had said that why Gandhi has not died as yet. So he was absolutely not concerned with what's happening in India. So these famines are man-made famines. Famines happen because of the breakdown of estates' distributive machinery, not because there is a famine of food grains really. He believes that there are deep and persistent disagreements about moral and political issues. I've already talked about reasoned disagreements have got to be there in a reasoned society where rational humans live together. And there has to be a continuing quest for those objective answers. There has to be a position of objectivity. So he talks about the role of an impartial spectator, though he also goes on to talk about an impartial international spectator. I will not go to that, but I'm just talking about the positional objectivity that he wants to achieve by the impartial spectator that he talks about. He believes that freedom is inescapably a plural idea. The contents of what constitutes freedom is something different for you. For some people, the freedom is in the nature. For some people, the freedom is in his AC house. So the freedom is a very different kind of an idea. The contents of the freedom will differ. Contents would vary, and not only freedom, but every value that actually informs a democratic system, a system which is informed by the idea of justice. So there has to be multiple types of freedom. So freedom to eat, freedom to wear the way you want, the freedom to, I mean, everything. So there has to be multiple types of freedom. Freedom is absolutely a plural idea. Public reasoning in a democracy is something. And you know, he talks about engaging with this public reasoning. Public reasoning in a democratic society is an essential thing, an element of empiricism, as I'm talking about. So there has to be a consistent effort at achieving some kind of a positional objectivity by, you see, looking into those multiple types of freedoms, by reasoning in the democratic way, you see. And he also believes that a state is not necessarily the best agency to protect, you see, the value of justice, not necessarily. So therefore, what he is trying to say is that there has to be a consistent effort on the part of the individuals, on the part of the collectivities, you see, to figure out as to what is just. Rationally, public reasoning has to happen. State significance, according to Amartya Sen, is determined by its contribution to human welfare, which is a distributor, which has a distributive role of goods and bads, as I have been talking about. And he says, I have already explained it, that famines happen because state machinery fails. And he also believes that if you have a flourishing media, famines cannot happen. So there are certain situations that he talks about, that if you have that engagement in public reasoning and flourishing media, all kinds of opinion flourishing, then the famines would not happen. Simply because people will not accept these things. People just stand up and will, you see, agitate for their own rights. So this is how Amartya Sen talks about the idea of justice. Very different idea than you see than Rawls is talking about, or even Michael Sandel is talking about, or earlier thinkers. He talks about, you see, transcendental justice and ideal justice, which he says applies to all kinds of people, underprivileged, you see, the people who are born challenged in any way. It applies to all. And for the purpose of making that story very simple, he quotes a Anne Bob Carla story in which he talks about a situation where there is one toy and he seeks an answer as to who's entitled for that toy. There are three people to claim it, three kids to claim it. One can play with that toy. Only one person knows how to play with that toy. Should he get the toy? A person has no idea. A child has no idea what the toy is. Should he give in that toy? And there's a third person or third child who has made it. So is it the child who has made it is entitled to that toy, or the one who has no idea of toy at all? So he is to be realized, he is to be informed, and he is to be made realized that, you see, that the toy is something like that, and it has the potential of developing your own personality if you play with it. Or one who can play with that toy, who is entitled for that toy? There are no answers. It is more or less like what you see Professor Dorkin talks about, a hard case. A hard case. You see, as to where do we find justice? There are no right answers to these questions. This is what you see he talks about. So pursuing justice is actually making comparisons. The idea that I have already been explaining, the basic idea is that if you get the right choice of institutions, that you don't have to worry about human behavior, is not correct. Kant would say this, that race, even in the race of devils, if intelligent people produce just institutions and just society, you see, if the institutions are properly designed, then even the race of devils will produce justice. This is what Kant says. But Amartya Sen would not agree with that idea. He would say striking or finding good institutions only is not enough. You will have to have, you see, the other idea as well, which is the transcendental idea of transcendental justice, as he talks about. So democracy, you see, for Amartya Sen is something which can best define as decision-making by discussion. Decision-making by discussion process. So there has to be a continuing engagement with public reasoning. Continuing engagement with public reasoning. Today you got an idea as to what public thinks. That is not an end of the story. You have to keep on repeating it over and over again, because the contents of the people will change, their ideas would change, and the very personalities of the collectivity would change. You know, the idea of a collectivity that we need to appreciate and understand. A particular collectivity may have a very different type of a character. If he gets a leader like Gandhi, the collectivity would turn into a different kind of a collectivity. If it gets a, you see, leader like Subhash, probably the collectivity would change colors. It would have a very different kind of a collectivity. You know, so there has to be the public reasoning would keep on changing. The ideals and the values will keep on changing. The contemporary elements would keep on interfering with your existing ideas. That the existing ideas are not something which will continue to be there as the ideals all the time. So there has to be a continuing engagement with public reasoning, not with reference to some ideas. So your ideas are open. Ideas are not pre-decided, but in practical terms, what people think is practical for them, what people think is for their welfare. There has to be a public engagement of these ideas. Deciding about the, you see, the major decisions taken by way of discussion in public. That is the way the justice element is achieved according to Amartya Sen. The idea of taking into account others' interests, he says, enables us to look at things from others' perspective. There are no ideals to guide us. Comparisons would guide us. What is good? You see, the consistent comparisons, consistent engagement is something that has to keep on happening. Justice in the ultimate analysis is a process. It is to be achieved in a democratic way through public reasoning with an open mind. Just three elements I'm taking right now. There are a lot of other things that I will not be looking into, but just for the purpose of summarizing the whole thing, to be achieved in a democratic way by engaging with the public reasoning. Through public reasoning, open discussions, and with an open mind, in the sense that your ideals are not fixed. Ideas might change. So ideas will not remain the same all the time. Ideas may keep on changing. And therefore, there has to be a public reasoning and engagement with that public reasoning for the purpose of arriving at those ideas through democratic methods which shall become or ensure justice, which shall reflect justice, which shall result in justice delivered to maximum number of people, all people, as he tries to say. Now, this is a very brief idea of what justice, you see, from common man's standpoint, from Rawls' perspective, from Sanders' perspective, from Amartyan's perspective. Brief idea of what justice really means. So I just summarized in a single sentence that I tried to, that I have been talking about for maybe more than an hour. Now, quickly, let me go through, you see, in Indian scene, how we have tried to reflect that justice element in our own system. Now, this is something we need to appreciate and understand, that justice is not an abstract expression under Indian constitution, and it cannot be. There have been a lot of discussion in the Constitutional Assembly as well. Justice is a defined entity, and this defined entity means justice, every expression for that purpose, even equality for that purpose, justice, equality, you see, liberty, everything is defined category. So justice is social, economic, and political.
I think he has lost his signal.
Yes, it appears so.
एक मिनट मैं कॉल करती हूँ.
हाँ, आप कॉल कीजिए. Yeah, I think sir has some connectivity issue. I think it will be resolved soon, so you all be here. Meantime, if you want to ask any question, you may also write in the chat box right now. Or if you want, you may directly ask to the sir.
वो ज्वाइन कर रहे हैं दोबारा.
Okay, ma'am, sure.
Hello, Seema, am I audible?
Yes, sir, you are audible, sir. Yeah.
Santosh, I'm sorry, my
No. Yeah, it happens, sir. It's technological era. We do not know what happened.
I
Yeah.
just
It's
didn't realize that it has uh, happened that way. Just a minute, give me a.
yeah, sir. You continue, sir. Yeah.
I'm just.
Yeah, it is very interesting lecture, sir. Indeed, I've learned a lot. So please continue.
Screen is there.
Yeah. Yes, we could see your PPT, sir. We could see your PPT.
Okay, so I
Yeah.
just go back to the idea of
Yeah. Yeah.
I was talking about. Okay, engaging with public reasoning. Okay, so the uh, I just talked about that. I hope I'm on the point like where I left it. That Amartya Sen talks about justice in its ultimate analysis as a process to be achieved in a democratic way through public reasoning with an open mind. These are the basic characters or
Yes.
basic constituents of the idea of justice that you see Amartya Sen talks about, which, as I said, means a few things that there has to be a continuing engagement with the public opinion, public reasoning. There is no definite ideal, and there has to be continued comparative processes which will inform our idea of justice, public reasoning, and it has to happen in an you see democratic way. Now, Dr. Santosh, I hope this is the point where I had left.
Yes, sir. This is the point where we disconnect. Yes, sir.
Okay. So with this, let me come back to the Indian Constitution, and I had started talking about it. That under Indian Constitution, justice is apart from being a defined entity in terms of social, economic, and political, is also a value that informs the other values of the Constitution. So I was trying to give the example of equality. So some scholars would say this, the familiar example from a common man's perspective. So a mother having two kids and 20 rupees to take care of them. Now, one of the two kids is a sick child, the other is a healthy child. So look at the behavior of the mother. The mother, what does it do is that it spends 10 rupees on the medication of the sick child, 5 rupees on the nutrition of the sick child, 3 rupees on the nutrition of the healthy child, and saves 2 rupees. Now, somebody might say that, look, she has spent 15 rupees on one child and 3 rupees on the other. This is absolute inequality. But if you look at from human perspective, she has done justice to both. She is trying to, you see, recover the sick child so that he might become a useful unit, you see, for the social system. So she is trying to retrieve, you see, which is not able to contribute to the system, being sick. So therefore, equality cannot really be talked in terms of a very straight jacket equality, in terms of equality before all. It has to be, you see, with that kind of a differential rule. And that is the way we understand equality throughout. Compensatory and protective justice is something I had already talked about. That compensatory justice is where, Dr. Santosh, you are able to listen to me?
Yes, sir. I can listen to you,
So
sir.
in case I tend to, you see, miss something, you please give me a ring or something if the network somehow lost some way. Okay.
Okay, sir. Okay, sir.
So compensatory and protective justice. And mind it, I have been talking about both elements, individuality and collectivity. So justice is to be seen from the perspective of an individual and from the perspective of collectivity as well. You know, in Indian context, we generally talk about two types of things, you know, though otherwise it is like the whole of cosmotic system is actually classified into three. We call it Vyasti, Samasti, and Paramesti. But you see, from the material point of view, looking at it from absolutely, you see, physical perspective, individual, this Vyasti and Samasti we can understand. So everything related to Vyakti, individual, his character, his destiny, his, you see, everything is Vyasti. And Samasti is the collectivity. So collectivity has a character, collectivity has a destiny, collectivity has a particular, you see, peculiar things. So say Indians are known for something, Russians are known for something, Japanese are known for something, very special quality. So collectivities also have their own character and own destiny. Therefore, the justice element also needs to be looked into from Vyasti and Samasti perspective. Please understand it. We have done it in our constitution in both perspectives. I'll just give you one example. You see, it's not possible to give every single dimension of justice that we have, we see, reflected in our constitution, but I would try to give you a broad idea of this justice element. So look at Article 275. You can just go back and read that article. But what it basically talks about is a very simple idea that the parliament, I mean, from 265 or 269 onwards, you have that formula for distribution of revenues for the states and all that. You see, now 269 has been substantially changed after the GST has come into play, but the rest of the articles remain the same. So Article 275 puts in that the parliament would have ultimate discretion. I don't remember the language at the moment, and I don't want to refer to the bare act, though it is there with me. But just the gist I'm trying to convey, that the parliament would have the ultimate discretion that if a state is suffering for some or the other reason, it can grant in its discretion any kind of a grants in it. And there is no limit prescribed for it. So if a particular collectivity, which is part of the larger collectivity called India, suffers for any reason, maybe a natural calamity or anything, the parliament can decide the amount of grants in aid to be given to it. Parliament is the ultimate, no binding. Though the system has designed its own rules, and every finance commission comes up with a new formula as to how these rules have got to be worked out. So NK Singh, the latest finance commission, 15th finance commission, I think, has actually come up with a very different formula altogether in terms of distribution of revenues and all that. So a lot of other things which we cannot discuss here. But the point I'm trying to make is that the macro element, the macro dimension of the justice, which I said the samasti dimension, the dimension of the collectivity, has been referred to in our constitution at several places. You see the entire, what is that, 13A, 13, wherein you have that commerce throughout the territories of India. What is that? Business commerce. I mean, this chapter particular. So the entirety of it is suffused with a lot of ideas of justice at micro and macro levels. So I just, you see, use the economics in language, both macro and micro levels, you have idea of justice, you see, informing the provisions of the Indian Constitution. The articles that we have in terms of 14, 15, 16, and several other articles that I should be talking about, they talk about Vyasti or the micro element of justice. So we need to understand and appreciate as to how the system is trying to, you see, and sometimes it happens that individual justice is sacrificed for the purpose of collective justice. Though, you see, as J.S. Mill would say, that for the purpose of a democratic system, you see, the individual is the ultimate minority. So every individual's interest has to be taken care of in a democratic system. But nevertheless, just one idea that might happen. And we are having all kinds of systems. There are quite a few more slides. I'll quickly rush through that. So that justice, which is compensatory and protective, we have in Article 14. We know this. I don't have to teach it once again. Equality before law and equal protection of laws, which means that it is not just mechanical equality, but equal protection of laws, where the law will move on to protect the unequal, and therefore unequal treatment for the unequal. That is the way that you see it is talked about. And therefore, you see, you have discrimination as a prohibited category, but for the purpose of protecting, you see, the discriminated, for the purpose of protecting them, discrimination can be made. Therefore, there can be special provisions for women and children. There can be special provisions for socially and educationally backward classes, and so on and so forth. Now, we need to understand and appreciate as to what type of 3 types of compensatory and protective discrimination programs that we have under the Constitution. So sometimes people think that, okay, reservation system is something that we have. Even reservation is, you see, in variety of expressions. So reservation in legislatures under Article 330 and 334. Some amendment has been made by 103rd or 104th Constitutional Amendment, whereby Article 331 probably has been amended, where under we had the reservation for Anglo-Indian community in Lok Sabha that we had. And I just don't remember the exact article, but this is how we have. So under 330 to 334, we had reservation in legislatures. Then in government jobs under Article 16.4, and then in education institutions under Article 15.4. There are other things as well, but I'm just looking at broad patterns that we have. Apart from that, we had special treatment in land allotment, housing, and scarce resources that we have. So there are a lot of emulation programs that government talks about. So these are some of the broad categories of compensatory justice, of protective justice, okay, that we have under the Indian Constitution. So I just talked about Article 330, talked about 330. You see, Lok Sabha for SC and ST category members, reservations. Then 330 talked about legislative assemblies. Then 333 talked about, 331 and 330 talked about members for Anglo-Indian community. That has been, you see, amended by this 103rd or 104th Constitutional Amendment. And then you have a limit prescribed for it. This is something very important that we need to understand and appreciate, that for this protective justice, you see, generally we understand that some limit has been prescribed. No, it is only for reservation in legislatures that time limit was prescribed under Article 334, 10 years to begin with, and it has been increased every 10 years. So now, in 2020, I think by 102nd Constitutional Amendment, the time limit has been extended to 80 years now, until it was 70 years until now. So this has been increased. For other types of protective justice programs under Indian Constitution, there is no limit prescribed. For Article 16.4 or 15.4, nothing like that. Then 335 talks about, you know, the generally a forgotten provision in the sense that we have never talked about it. I just remember one judgment of 1999, if I'm not wrong, Preeti Srivastava versus Union of India was the judgment, in which Justice Sahai has given that, you see, very interesting interpretation of Article 335. But if I look at a lot of judgments that we keep on reading, even you see the recent judgments by the Supreme Court in what is that, Judge Sri Patil, State of Maharashtra, something like that. A lot of other judgments as well. Supreme Court keeps on talking about several things, but 335 is very, I mean, it is not talked about. What 335 talks about is that for the purpose of providing, you see, jobs for the underprivileged classes or any kind of a thing, the administrative efficiency shall be taken care of. That shall not be compromised. Okay, that is something that it talks about. That has not been, you see, taken care of by the courts and whatever reasons. Then Article 16.4 and 15.4 I have already talked about, quickly rushing through. I just try to explain from the point of, from the perspective of protective justice or compensatory justice. You know, there are 2 types of this. Classification has become very popular during 1990s and later. One Professor Oppenheimer, an American professor, I don't remember from which university he comes, but he talks about, and this kind of a classification is very familiar for international law students, what we call hard law and soft law. So therefore, protective justice or protective discrimination program, or as it is known as in American system, affirmative action program, can be of 2 types. I'm just taking that particular narrative or that particular paradigm to explain the idea of protective justice. Hard provisions under the Constitution and soft provisions. Hard provisions simply means the provisions that are available in all or nothing fashion. They have got to be done. So there is a clear cut, mandate that this has got to be done. And then you have soft provisions. Soft provisions, this should be done. So for example, the kind of a difference that you have under Part 3 and Part 4 of the Constitution is something that can be understood in terms of soft and hard provisions. So the fundamental rights is something that have got to be implemented. There's a mandate for that. And then you have directive principles. So as and when the state is capable of doing it, state will do it. So state shall take into consideration these directives as and when it prepares its policies for the purpose of ensuring justice. Okay, this is how it talks about. Now, looking at the protective justice from this perspective, you have several things that I will not get into the details. Special provisions for this soft protective justice under Article 15(4) and several other provisions. Then you have, soft format is available under directive principles that I had talked about, that wealth and source of its production shall not be concentrated. There shall be adequate means of livelihood, equal pay for equal work. These are some very familiar things that we know as students of law. Health and strength of workers shall be protected. Just and human conditions of work shall be ensured, and so on and so forth. These all things are the soft compensatory justice element. I have a purpose. I'll just rush through this within a couple of minutes and probably explain it further. Now, in pursuance of this soft, protective justice program, Constitution has done, the government system has done several things. Land distribution and agrarian reforms is one. Zamindari abolition is one. Healthcare programs are one. So, for example, primary health centers across the country. So, distributive justice scheme to protect the backward classes from exploitation and victimization, several such. And then removal of incapacities, prohibition of forced labor, anti-untouchability programs. These are all programs which, when implemented by the system for the purpose of ameliorating the conditions of the underprivileged section of the society, the discriminated section of the society, the less privileged sections of the society, the least disadvantaged section of the society. Now, this has been done, and you will appreciate this, that the kind of an impact that the system has made is through soft protective justice programs. This is what I'm trying to explain. Probably it shall get explained in the later slides. Now, looking at it, what are the justice imperatives? Without getting into the details, I'll come back to this. The justice imperatives in Indian conditions is that the protective measures which lead to backlashes and heartburns. So say, for example, if you provide, say, 50%, 60%, 80% reservation, it leads to backlashes and heartburns in those people who gets deprived because of, excessive reservation system. So the justice imperative is, as I understand, that there has to be limited range of protective measures to, in those areas where backlashes and heartburns are to happen, there has to be very limited range. And the emphasis should be on amelioration programs through soft law approaches, soft protective justice programs, which I explained in the earlier slide. Therefore, there has to be a consistent effort. Remember, the Amartya Sen, continuous engagement in public reasoning, continuous engagement with, the comparisons. So you will have to keep on reviewing and giving signals that program is not meant for perpetuity. Social engineering, whereby we try to balance one community against the other, it should be done not for the purpose of dividing people, but for the purpose of, ensuring that, some kind of a balance is managed. So divisive factors should be avoided, whereby, soft programs can obviously have a better impact on this, evaluation programs and all that. So one very small thing that I would like to discuss in another couple of minutes is, some people, I have already explained that there was no idea of some period being mentioned for the kind of protective justice that we talked about under the Constitution in variety of formats, in legislatures, or for that purpose in jobs, in schools, colleges, and several other areas. So say house allotment, land distribution, and so on and so forth. So there was just one area in which the limit was explained. That was the legislatures. So the idea that emerges, the argument that is made is that for others there is no limit prescribed. But if you look at the whole Constitution in one go, and recent amendments have been made under Article 340, 342, you look at it, it talks about that the president shall, fix a commission or appoint a committee to look into as to which communities have come up which do not need any state support. Now, what has been happening is that the schedules that we have, prepared, these schedules, more and more castes are getting added. But I do not remember any time when some castes have been removed from these things. So what Article 340, 342 talks about is that this idea of protective justice is not something which is a permanent feature of the Indian Constitution. It is something which is continuously to be reviewed, continuously to be public reasoning, public comparisons has to happen of all these programs. And these provisions, have not been properly utilized. 340, 342, or 41, 42, etc. And then 335, etc. These provisions have not been properly utilized by our system. So I'll just give another small argument that in any system for that purpose, the perpetuity, the protective justice in perpetuity is nowhere available. So I just, pick up a case of 2003 of US Supreme Court, Grutter versus Bollinger. And this is a small quote that I have quoted here. They talk about several things. It is about protective discrimination, Title VII, judgment that in very peculiar expression that we use for the purpose of protective justice program in US. They also call it affirmative action and all that. The judge writes this. We are mindful, however, that a core purpose of the 14th Amendment, which is like our Article 14 and rest of the provisions, that the core purpose of 14th Amendment was to do away with all governmentally imposed discrimination based on race. Accordingly, race-conscious admission policies must be limited in time. This requirement reflects that racial classifications, however compelling their goals, are potentially so dangerous that they may be employed no more broadly than the interest demands. Enshrining a permanent justification for racial preferences would offend this fundamental equal protection principle. So if you enshrine something as a permanent protective justice program, it is going to demolish itself. And in Ashok Kumar Thakur, I'm not sure if I have quoted that judgment here, but if it is there, it will come obviously. But in Ashok Kumar Thakur in 2008 judgment, without referring to Grutter versus Bollinger, Justice Bhandari is almost saying the same thing. The last, you need not look into the whole judgment, which runs into 500-600 pages, but you can look into last two paragraphs. A beautifully written judgment by Justice Bhandari, wherein he says that the ultimate justification for any kind of a protective justice program lies in its gradual self-annihilation process. In its gradual self-annihilation process. I'm repeating it. So any kind of a justification for these programs has to be that they self-annihilate themselves. That has not happened with the kind of a justice program that we have. Judicial responses, if you look at in Indian context, and Justice Ashok Thakur judgment I'm quoting here, for first 30-40 years, judicial responses were just managing contradictions, not exactly, rollback process that Supreme Court starts talking about in the Sahani was not there. So rollback in the sense that creamy layer. So now for creamy layers, you cannot give reservations. So, but that is there only for OBC classes right now. It's not available for SC categories because it's a constitutional, category that way. So in Indra Sahani, Supreme Court realized that this program has become too big, and therefore some kind of a rollback process has to start. And in Ashok Kumar Thakur, almost in the same vein as Grutterbus Bollinger, US Supreme Court is putting it, this is Bhandari puts it, that it has to happen. You see that it slowly self-annihilates itself. That is the way protective justice program has to justify itself in Indian context. There are a lot of other judgments that I'm not getting into now because my time is coming to a close and I wanted to keep 10-15 minutes for question answer session. I'm not sure if there shall be questions, so I just take another couple of minutes to rush through one or two slides, whatever I have. What kind of criterion should be used? So in Ashok Kumar Thakur's case, Supreme Court has, I'm just looking into this judgment in a slightly, looking into more details. 4 judges articulate their opinion as to what kind of, approach towards caste should be there. They believe that objective of casteless society can never be achieved by ensuring a caste-based protective justice program permanently under Indian Constitution. So they believe that some kind of an economic criteria should be used. So therefore, the suggestion is that government should ensure that for a period of 10 years, caste and other factors and occupation, income, etc., should become the criterion for providing this protective justice program, and then they should slowly be replaced by economic criteria alone. That is the kind of a justification that you have in Ashok Kumar Thakur's case. These are my concluded observations, which should not take more than a couple of minutes. Friends, as far as the system that we had under Indian Constitution, it's a perfect theoretical justification for the kind of a protective justice program that we had under the Indian Constitution to begin with. But political process that followed, which underlined the caste and class differences. Mind it, every single election, and I recall a meeting that happened, in 1951 in Meerut, and the minutes are available somewhere on the records of Congress Working Committee, in which because elections were planned for 1952, so the Congress Committee decided the broad principles of electioneering. And in those things, the names of the candidates were decided on the basis of caste, etc. So it's not that caste has become slightly relevant only during recent days. Right since those days, even elections had been fought on the caste lines. And every single process, had been happening on caste lines. At one point of time, particularly if you look at, say, from 1967 to 1976, 77, there are huge number of cases in the Supreme Court, in which Supreme Court, initial stages, Supreme Court keeps on saying, caste alone cannot be the determining criterion for, providing protective justice. But slowly, Supreme Court starts saying, caste can be equivalent for backwardness. It changes its position. So this is, the even judiciary has followed the process that political system has followed, which has actually underlined the caste differences. So political process that has followed has violated this the spirit of these provisions that I had just talked about. So it has been done obviously for the political dividends and not exactly for doing justice for the larger population, which has resulted in what I call displacement of objectives of this justice program. There has to be an imaginative thinking about it. There has to be some kind of a bipartisan approach on this point. I'm sure that you must be knowing what do I mean by bipartisan approach. Partisan approach is when you think in terms of one side, partition approach. Bipartisan, when you talk about both sides. So very familiar, the political science students, those who have studied a bit of American political science or American political system, they might understand it better, that there is a bipartisan approach. And for a long time, you will see in those presidential election debates on TV that some issues are never articulated before the public. because there is a bipartisan agreement amongst the political parties that these issues are issues of core national interest about which no debate shall happen in public. Now, in our country, that kind of a bipartisan approach has never happened. That is the kind of approach we need to have. If we can, I just go back to what I see, put it in the one of the slides in summarizing Amartya Sen's understanding of justice, that fourfold formula for the purpose of ensuring complete justice. There has to be a continuing engagement with the public reasoning. It has to be without ideals in place. So there has to be an empirical element about it. And it has to happen in a democratic way. And final thing, there has to be, in the days to come, a bipartisan approach towards core ideals of justice that we are going to pursue in the days to come. If that is not done, the displacement of objectives of justice program that has happened might continue, and we might never be able to achieve justice program. Friends, the last thing is, thanks for very patient listening that you have given to me. Thank you so much. We have still 5-7 minutes and we can move on if necessary. I think I stop sharing so that we have a slightly better space for discussion. Over to you, Dr. Santosh.
Yeah. Thank you, sir. Thank you, sir. Now, floor is open for questions. I think Dr. Anjay Sharma is here. Sir, one of our colleague, Dr. Anjay Sharma, has written just a question or comment in chat box. I'm just going to read it for your response.
Please.
Sir, very good evening, very informative lecture. My question is related to the name, like what you started, like International Court of Justice, ICJ. So here, word justice used, but name of our apex court is Supreme Court of India and not Supreme Court of Justice, question mark. So what is your reply to this?
You see, broadly, the nomenclature is for the purpose of distinguishing those Supreme Court of Pakistan, Supreme Court of India and all that. I did not talk about that, in fact. I talked about the generality of courts. Supreme Court refers to a particular hierarchical arrangement for the purpose of structuring the system in a rational manner, as it has been done in other systems. So we have also studied those peculiarities of the system, and we have tried to arrange our own court systems in a certain hierarchical fashion. It could never be said to be Supreme Court of Justice. So therefore I said courts of law are known as courts of law, all kinds of law courts. Supreme Court, High Court, or any district court or subordinate court or whatever. They are known as courts of law, not courts of justice. So I was trying to say that probably those people who coined these expressions were aware that courts of law have their own limitations. Then they cannot deliver justice. Now, Supreme Court of India, being at the apex, has been given that very special privilege of doing things for complete justice that are not possible for other courts. So Article 142 is there. But that is only one small area where you see the courts can really go anywhere and on any in any area whatsoever for the purpose of doing complete justice. So I did not refer to probably some difference of opinion as to the nomenclature. My understanding is that this nomenclature is for the purpose of hierarchical setting, rational arrangement of our institutions hierarchically, whereas he is talking about those contents of these courts, that why they are not really designated as courts of justice or Supreme Court of Justice, not like that. So these are two different ways of looking at it.
Okay, thank you, sir. Any other question or query participants wants to ask? So, yeah, there is one more question from our PhD student, Mr. Himanshu Atri. I'm just going to read it in chat box. Sir, when we talk about the caste, it is based upon the recognition of the society towards that community identity. then how come economy defines the discrimination? Because the discrimination is based upon the social identity, not upon class. Isn't it in itself unjust to define the standards of discrimination upon the understanding of those who are not victims?
I perfectly appreciate it. There is no, I have no bones about it. This is perfectly in order that you see defining people on this or that line is unjust. Let me tell you, there are a lot of arguments on the other side that caste is an element of identity. For example, Mark Tully in his, what is the name of that book? I recall if I'm right, there are no full stops in India. That is the name of the book, in which Mark Tully talks about that you see that decrying or you see demolishing the caste system without appreciating the reasons of that is also some kind of an injustice. He talks about it. But no conscious effort in our political system has been made during last 70, 80 years, whereby, as Rajni Kothari puts it, the function of the politics is, as Rajni Kothari puts it, I think that would be the right way of explaining it. Rajni Kothari says, the function of politics is to identify the clusters of people and draw them to the polling booth. Now, castes are already identified clusters. So we start working on the caste system immediately. So we identify this group, that group, and try to bring them to the polling booth by appealing to their caste identities. That's how we started. But the long-term program should have been, because casteless society can never be achieved by underlining caste differences. And at the moment, at every place, caste differences are being underlined by the political system, by the judicial system, by the executive system. Everywhere you have those identities are being, underlined all the time. So increasing that hiatus between the backwards and the forwards and so on and so forth. So what should have been done? That is the question. And my tentative answer is that we should have tried to recluster the people. So say, for example, just by example, this is not an ideal experiment, but an experiment has been made in the state of UP during last 7-8 years. So they now call it there is a new category of, there's a new cluster. Now they call it Labharthi, which come from variety of categories. So they are from forward caste, they are from backward caste, they are from SC categories, from ST categories, but they were identified on the basis of their economic status, and then they were identified as clusters. Certain benefits given to them in the form of a cluster. Now, we never identified those clusters. This could have been done. So say, for example, doctors' societies or doctors' clubs, or say, for example, railway employees union, or say, for example, Safai Karmachari union. No, these are different clusters that we could have created. We never made conscious attempts about it. Now we are like in the dark because not much has been done, so we don't know if anything can be done about it. But I believe that a lot of experiments can be made in the political field whereby reclustering can happen. And I believe it shall happen in the days to come. I'm confident about it. Because we have realized that castes benefit nobody. Either the people who get benefited in the name of caste, nor the people who get deprived in the name of caste. It benefits nobody. So these things have come to an end in the days to come. There's no confusion in my mind, and reclustering of the political system has to happen. That is my brief answer.
Okay, so thank you. So I think there is no other question, and so also we are running a little late. So now I will request our respected colleague, Dr. Seema Singh ma'am, to give concluding remarks and vote of thanks. Yeah, over to you, ma'am.
Thank you so much, sir. It was truly a very insightful lecture. And as I always discuss with my PhD students specifically, that in our PhD classes, when we are going to deal with the fundamental perspective of law, we are basically going to create a bridge between what law is and what law ought to be. So this theories of justice is a very broad concept, but correct me, sir, if I am wrong, because I always feel that whenever we discuss different kind of theories, which you have discussed in a very elaborated manner. One thing is missing, or one thing which we find difficult to define, and I think which you have defined. What is the meaning of justice? The rest of the things become secondary. The most important thing is what is the meaning of justice. And as you told, that this thing, Matsya Nyaya, means whatever is not the Matsya Nyaya, that is the justice. That is the most fundamental aspect. And that also talks about giving protection to all those who are deprived. And once we are going to talk about these different kind of theories, sir, a very important aspect which you have discussed right now, and that was the aspect which was given by Mr. Amartya Sen, Dr. Amartya Sen, in his book Idea of Justice, and you mentioned an example. So I just wanted to, because whenever we discuss the philosophy of the law, a very important philosophy which we normally don't discuss, specifically when we are going to deal with the philosophy of law, and that is the philosophy of Indian thinkers. And I know this is a core area of yours, and I am also learning a lot of things from you. तो एक मुझे इसमें जो बड़ा इंपॉर्टेंट लगता है सर, जिसको कि मैं क्रिटिसाइज करती हूँ, आई मे बी रॉन्ग, द एग्जांपल व्हिच वाज गिवन बाय मिस्टर अमर्त्य सेन, एंड ही सेड कि किसको देना चाहिए, इट हैज डिफरेंट पर्सपेक्टिव. व्हाट आई पर्सनली बिलीव दैट जस्टिस इज समथिंग व्हिच इज मोर अबाउट सर्टेनिटी. अभी एक क्वेश्चन पूछा गया कि व्हाई नॉट सुप्रीम कोर्ट ऑफ जस्टिस. This is not maybe because of Supreme Court of Justice, as you rightly said, that they are not sure that is the courts of laws and they are not the courts of the justice, and that is the reason that the judgment is going to be changed from the first court to the highest appellate court, and itself reflects that there is no certainty of the idea of justice. But once I tried to fix this problem which was raised by Dr. Amartya Sen in his book, there is a very beautiful story in Mahabharata, and because sometimes what we compare, that the right and adhikar, they both are the same thing, and I think this is the fundamental flaw which I think we all should discuss. And the basic difference between right and adhikar is, adhikar means firstly we should deserve and then we should desire. But the problem with the right is we want rights irrespective of the fact that whether we deserve or not. So if we are going to apply this Indian philosophy over the problem which was raised by Dr. Amartya Sen, that then as per me, the flute or the toy should go to the person who knows how to play it. So that is the answer. But what Amartya Sen has done, he has created different perspective, and so he is not able to destine that where actually through this problem he is trying to reach. And another very important with which I would like to conclude, sir, because you have talked about the similar thing, and the problem in identifying the justice. And once we talk about the justice in the case of India, the culture is very much important. Abhi kal sir JNU mein hua hai, between the non-vegetarian and vegetarian food, a lots of discussion was going on. And एक उसमें मुझे बड़ा अच्छा लगता है कि अगर आप अपने बारे में सोचते हैं तो ये आपकी प्रकृति है, अपना अच्छा सोचते हैं. अगर आप दूसरों का बुरा सोचते हैं तो ये विकृति है, और अगर आप सबका अच्छा सोचते हैं तो संस्कृति है. तो ये जो संस्कृति है, दिस इज द मोस्ट फंडामेंटल पार्ट ऑफ द जस्टिस, एंड दैट इज द मोस्ट फंडामेंटल पार्ट ऑफ द इंडियन कल्चर. तो सबका अच्छा सोचना, व्हाट आई फील दैट वेयर इज द प्रॉब्लम लाइज स्पेसिफिकली वंस वी आर गोइंग टू डील विद द वेस्टर्न फिलॉसफी, वो सिर्फ प्रकृति और विकृति के बीच में घूमते हैं, एंड दे आर नॉट पुटिंग सफिशिएंट एम्फेसिस ओवर द संस्कृति. तो इसीलिए द मेन क्लैश इज बिटवीन द इंडिविजुअल इंटरेस्ट and the greediness, and that is the most important concern, or most important reason that we are not able to determine that what is the idea of justice. So with this, sir, this was the point which I took out from your lecture, and I think, sir, it was right. If you want to correct me, then please correct if I made any mistake. But this is something which is definitely a very important point, because most of us are talking about the justice system without understanding that basically what is the meaning of justice. So with this, sir, I extend my thanks to you for giving your valuable time to all of us, and for delivering such an insightful lecture for all of us. It was definitely a great benefit personally for me, and definitely for all of us. And I will also extend my thanks to both my colleagues Santosh and Ajay, my Dean Professor Usha Tandon ma'am, my all the respected colleagues who have joined this program, and especially all the PhD students and other students who are with us for since past 2 or more than 2.5 hours. With this, sir, thank you so much, and I will keep inviting you and disturbing you to deliver.
Thank you, Dr. Seema.
Your share.
the ultimate thing is there are no final answers.
Yes.
Continuing engagement with the
Exactly.
with public reasoning. That is the way things will happen.
Thank you so much, sir.
Thank you so much. Thank you so much for
Thank you,
giving
sir.
me this opportunity.
Thanks to all of you.
Enlightening. Thank you, sir. Yeah.
Thank you.
Thank you, sir.